workshop. So this follows on from the workshop which we held earlier, which was for an information session. And so welcome to Greg and JP. Before I start, could I ask Councillor Waru to opening our workshop with a karakia, please?
Tēnā koe te tiamana ki ainoi tātou. He honore he krore ki te atua e maungaro mo ki te whenua he whakaaro pai ki ngā tāngata katoa amini. Tēnei mātou wā aupononga tuku whakawhetai tōne ki a koe e te atua. Toro mai tori ngata pukiringi i a mātou e where haere ana i nei kaupapa nui whakaharara i tēnei rohe o Rotorua. Tēnei rā te whakamuimiti atu ki a koe, i runga i te ingo te matua te tama te wairua tapu. Āmin.
Tēnā koe, Councillor Waru. So, Greg and JP, we're in your hands. You've got a presentation this afternoon.
Good afternoon, councillors. Thank you for the time this afternoon to talk a little bit about the local alcohol policy and the review of that and development of a statement of proposal and evidential base for us to consult with the community on some further options down the line. I think just to kick it off from a little bit of context, again, as we've spoken about in previous workshops, there's a whole range of policy and bylaw opportunities for us to be looking into, and really forms a broader context of community harm and areas that we can focus on. Obviously today we're talking about the local alcohol policy. So just following on from what JP spoke about this morning, but also from previous workshops, we're currently looking at a couple of policies and bylaws. Obviously, the dog control bylaw and policy was adopted now in September on the 25th. We're looking and reviewing at the local alcohol policy. We have had a workshop on the Class 4 gambling policy already, where we will have to do a little bit more work in gathering some information from trusts, and with the proposal to possibly roll over that policy, but then work outside of that policy in an advocacy role for funding and working with the trusts going forward. The livestock movement bylaw, that's another one that we have been reviewing over some time. We've had some legal advice on this, and we've done some research on this one, and we're really questioning the intent of that bylaw itself. So we don't believe that bylaw in its current capacity is really fit for purpose, for what it's supposed to do. We don't believe there's enough information in that bylaw. And anecdotally, a couple of conversations with some of the farming community don't even realise there's a bylaw that exists to manage the movement of stock. So we've done quite a bit of research on that one, and really our proposal on that one would be to allow that one to lapse and then work with the Rural Community Board and other farmers and federated farmers to understand what their requirements would be. There is other legislation, national legislation, that sort of doesn't supersede the requirement for movement, but does put the onus on the farmer to manage that process. So this is not a workshop about that, but I thought I would just give you an update on that specific bylaw, and then with the opportunity to work with the Rural Community Board and the farmers going forward on what that looks like. So just quickly, I guess there are two possible options. We could allow that one to lapse and then let it be. We have had, I think, no enforcement of that bylaw in the last 5 or 6 years. A couple of requests for permits in the early days when this was first brought in. We do realise that there's a wandering stock component that we need to be looking into, and that can form part of a general bylaw discussion or other areas. This is really around the moving of stock from one land or field to another across a road. So we're busy looking into that one, but that's sort of where we've landed on that one, and I just want to let that one, just bring that to your attention this afternoon. Just a quick recap on the local alcohol policy. So it really is a set of decisions made by yourselves in consultation with the community about the sale and supply of alcohol in our area. Once an LAP is in place, licensing bodies must consider it when they make decisions about alcohol licensing applications. So that would be our district licensing committee. So the Rotorua LAP This can impact pricing through conditions, amenity and good order, noise nuisance, and vandalism, alcohol advertising at street level, front of house sort of stuff, density and availability, trading hours, and really there's quite a lot that we could go into, and I think we'll touch on some of that today through the presentation. I'm not too sure if you can see that, but we do have a timeline of this review, and we have kicked this off a few months back, and we're working with Dr. Grant Hewison in the creation of our evidential base, and working alongside a number of government agencies, Ministry of Health, the police. That's a legislative requirement, but if we want to do this properly, we really need to make sure we're working with the right people and getting the right evidence to be able to support some of the decisions that you would want to make later on. We're wanting to work with some key stakeholders over October, November, and then bring you a statement of proposal at the end of November for adoption to consult. And then look at consulting for a number of months from December through to February, and then come back for hearings and deliberations leading into adoption in April. So that's sort of the draft timeline at this stage. And I think I'll hand over to you, JP.
Yeah, councillors, and it's probably worth us emphasising, and we had it from the District Licensing Committee Chair, as she presented previously, and also with Dr. Hewison being involved, there's a lot of case law in this space, so the evidential base is quite important. So we're very conscious of spending the time ensuring that we've engaged properly with New Zealand Police, Health New Zealand, and some of those other key agencies to make sure we've got that evidential base in place, so that the robustness about whatever is proposed to you in that statement of proposal is really, really clear. So, however, this session was just a chance for us to start giving you the verbal feedback that we've got, anecdotal information, the direct conversations we've had with police, or responses on our own evidence around things like noise complaints and nuisance complaints, particularly after hours. So we've got some of our own information, but really we're waiting on Health New Zealand and the New Zealand Police to make sure that their stuff is put in a way that really does give some certainty to your ability to make some decisions. The other point I would make is, because of course it goes into a statement of proposal, anything that's not talked about in the statement of proposal, we can not really go to. So there is almost this need to say, if there's an option to take some of that information and say, actually, here's a statement of proposal, it needs to be in the statement of proposal, because through public consultation and engagement and that feedback process, you can come back from that. But it's very difficult to start at the status quo position and move out, because you didn't consult on that. So that's just a warning of why we're starting to suggest, from what the conversations we have had with those critical stakeholders, that it's more about saying, okay, where do we move from to? And then there's a chance through that statement of proposal for the community involvement to bring it back. So just being really clear about that's the stretching part of this kind of conversation. So as a consequence, one of the key things we've got there is hours of operation. So again, this goes back to police feedback and also the evidence out of Auckland and some other localities that Dr. Hewison will be bringing together. The unique circumstances that council itself has created around Eat Street. We had a alfresco dining space. We've legitimised significantly additional space for them to operate, as well as providing a roof over it, and that has created some unique circumstances which make Eat Street distinct from the rest of the CBD, from the environment it's created. A really important question for us too is when is enough enough? So a number of localities have picked up on some evidence around the proliferation and the number of off licences and bottle stores that are in a city. So again, that's another piece of evidence that we just need to bring together about saying, have we reached a point where that gives us an opportunity to make a decision in that sort of space? So we'll drill into these in a bit more detail. And then the opportunity for the district licensing to be able to consider the unique circumstances and apply a range of discretionary conditions around offering licences. Again, recognising the unique circumstances or the physical nature of the building or the premise involved. So them having more discretion around what kind of conditions should be imposed. So that needs to be detailed within the policy as well. So as I said, we've got a very simplistic local alcohol policy at the moment, and what we've seen now from Auckland and a number of other centres who've progressed subsequent to when ours was adopted, there is a growing set of evidence that really we need to sort of consider and see whether that alters our policies.
So what we'd like to take you through today is breaking down those bullet points that we just saw on the previous slide, and actually talking a little bit about what a proposed direction could look like in that space, as well as some of the other surrounding councils or some of the other councils across the country and what they're doing in that space. And that's just to provide a little bit of context. So off-licence trading hours. The current local alcohol policy that we have is an all-week 7 a.m. to 10:15 p.m, except from a window of the 11th of December to the 24th of December, which is a 7 a.m. to 11 p.m. So that's our current times that off-licences are allowed to sell liquor. And the proposed direction, I guess, is taking a look at what did the Auckland case do, what evidential base did they bring forward, overlaying our local experience over the top of that and our local set of circumstances. And then there's, an opportunity to have a look at, supermarket trading from 7 a.m. to 9 p.m. or off licenses from 9 a.m. to 9 p.m. could be on school routes as well. So just having a look at what is the unique set of issues that an earlier trade or an opening of an off license could create for school children walking to school. So there's a bit of an evidential base we still need to build up across that space. We know that Auckland went in with a 7 a.m. to 9 p.m, and that is what has been dragging on for a number of years through the courts, and they did manage to win that one recently, and so they are closing their off licenses at 9 p.m. We've got a range of other locations that you can see there. So Tauranga is a 7 to 10, Gore is a 7 to 11, and then the rest down there. We've got Kawero and Whakatane are actually a single local alcohol policy for the region, but they've got a differing times there.
So just adding to that, and it's one of the situations we'll be looking to do is just to plot those proximity of some of those off-licences in supermarkets. So the off-licence locations compared with schools, bus routes, bus stops, that kind of information, just to get that understanding of those hours of operation. Again, but it becomes part of that evidence of is there an issue or is there not an issue? And probably one of the interesting points that would be raised there is often we might have a supermarket in very close proximity to an off-licence or a bottle store, and is it fair to have one operating from 7 and one operating from 9? So again, it's one of these questions about closeness to the street, the visibility of the premise, a difference between an off-licence or a bottle shop directly onto a street versus sale of alcohol embedded within quite a large format supermarket. So there is some differences there to consider, but we just thought that was an important one, just to sort of indicate probably the most consistent issue we're starting to see is that that question and the testing that was occurred in Auckland around the closing time. So the operating or morning time is a point there about just proximity and that nuisance effect almost. So that's something we'll just have to bring back to you, but there's some information for you.
I think also important to note, one of the pieces of work that we're doing at the moment, or the team is doing, is understanding while the local alcohol policy may allow you to open at 7 a.m, realistically how many are. And so we're busy building that picture at the moment to understand, is a change going to be of massive consequence or not. So that's a piece that we're busy with at the moment.
Actually, Greg, just before you go on to the next slide, so I just want to question with you how we want to take this. So we've had the background information that's been provided through Karen Hunt and the District Licensing Committee, and we had Grant come and also assist with that. And then based on that, this slide is giving sort of current policy and then where to we potentially could go. So given that these are all sort of different, unique sets of circumstances, do you want to take this one slide at a time and get some? So once again, this is just a workshop, so we're trying to provide a direction of travel, if I think I use your words, in terms of what the policy might look like when we go out for public consultation. Just bearing in mind JP's original words that we can go out here and we can bring it back based on public consultation, but we can't move from here and go back out. So we need to make sure that we have a robust discussion up front about what the potential policy might look like if we go out for public consultation. So at the moment you'll see 7 till, let's say, 10:15 to 11ish. Auckland case is to define 2 different things between supermarkets and off licences. And so are you wanting us to kind of give you a steer as to, do we really want to go out with something like that proposed direction in the right-hand box?
I think it's part of that is, yes, we do, but I think the other critical piece is there any other information you would like to support your decision making when it comes time to start looking at the specifics? We've talked about canvassing the off licences about their hours of operation anyway, and is this actually an issue that exists or not? And again, so that's a very specific one. The plotting of schools, bus routes, all those kind of things on that kind of stuff. So is there any other information you would like to see that potentially we may not be bringing to a discussion? So 2 parts, yes.
Okay, so with that, Councillor Brown.
Madam Chair, just reviewing the proposed directions in some of these, and given I've got 2 liquor licences, I actually think it's probably better that I withdraw from this and maybe just take a seat rather than participate in this conversation, because I do think I've got a conflict of interest.
Councillor Brown, it's really for you to declare your own conflict of interest, and so the rest of us can't really, and I can't as a chair, direct a conflict of interest. The Chief Executive has just mentioned this is a workshop. However, if you feel more comfortable given your commercial operations that you would be best removed from this discussion, then that's for you to make that decision.
Thank you, I do. It's not how the public might see it, it's how my competition might see my input, so I think it's probably best I withdraw.
Thank you.
Thank you.
But you'll stay and listen anyway to the debate, so thank you for that, Councillor Brown. So councillors, let's go back to this off-licence thing. The proposed direction, Auckland case, is to reduce the hours in terms of when alcohol can be sold and differentiating between supermarkets and off-licences. So Councillor Patterson.
Thank you, Madam Chair. Through you, just you touched on the information going to be provided to us. Will that be, let's say, for example, a map that says this is where all of these are in relation to the schools, etc.?
Yes, that's correct.
Thank you.
And we'll probably make also sure. So there's a couple of pieces that I think former Councillor Hunt, and Chair of the DLC, mentioned that there has been some other studies done about the sale of alcohol times and where that occurs. And again, I think one of the things she highlighted from this other study information that needs to be brought is that capacity for the use of off licences for the preloading, and that creates an on-licence issue. So we're starting with the off-licences, an on-licence issue of that. So again, that's part of that evidential base, which was also part of the Auckland conversation as well. So yes, we've got to make sure all that package of information's correctly there, because this is probably one of the most challenging bylaws we have.
Councillor O'Brien.
Thank you, Madam Chair. Sorry, just before I ask my question, could I just clarify a point with you? So I understand that today is a workshop. However, we're seeking to give the staff direction. Is that, some form, is that what I understand? My only concern is that we've yet to hear from, say, the Police, Medical Officer of Health. We've heard from the former chair of the District Licensing Committee, who, shall we say, had a particular set of views, which, some I agree with, some I don't. I'm just a bit concerned that at the moment, until we hear from the police or see actual evidence, to be asking us to start giving directions to the staff might be somewhat, not prejudicial, but we may be yeah, it may be more premature at the moment. I'm still happy to move with today, but I hope that there's another opportunity to have when more evidence is presented to the committee.
Yes, I think we were trying to find a date that we would have allowed that opportunity for the police to come, but as I understand it, where the police were in terms of the calendar, it was almost going to be too late for us to fit it into our schedule. So I know that, Greg, if you want to comment, but you've had some discussions.
Yeah, so we've requested information through the police and through the Ministry of Health. We're expecting that to come back to us sort of the beginning of November. And then that information will form part of the evidential base. We currently have Dr. Hewison putting that together, which is around about a 50-page document at the moment. But we will be plugging in all of the evidence that we get from them, which will then be shared with you as soon as we complete with that.
So sorry, Dr. Hewison's doing the gambling as well as liquor licensing advice, is that correct?
Yes.
Oh, okay, interesting. Okay, thank you for that. So if I can move on. So the supermarket that we have here, sorry, being on off licences, supermarket 7 a.m. to 9 p.m, off licences 9 a.m. to 9 p.m, school routes. So is the school routes in question for supermarkets as well?
And that's going to be one of the discussion points. At this stage, what we've seen from the Auckland case is no. So that's why we're just looking at sort of saying, the question I think is key, and what we were wanting to test here is, should it be the same regardless from an off-licence perspective, or should we be making a differentiation between supermarkets and off-licences? So again, there'll be some global pictures and some information about alcohol consumption and sales, which may support the nuance of a difference, but broadly I think one of the issues is it's more the prominence and the visibility potentially on the street that may say actually there is worthwhile being a separation, but we don't have the evidence base. But that's just the kind of anecdotal information we've got at this stage. So that's why we're sort of needing this kind of steer of saying, is it more important for the consistency or the nuance of how people see alcohol and the bottle shop type approach?
I suppose this is where I'm slightly having a problem with what the objective of today is, because if there's still evidentiary, to come before this committee, or sorry, in one form, a report, whatever, it's hard for me to sort of say, because the supermarket, for example, only sells beer and wine, yet off-licences sell the lolly waters, which we know contribute a lot to preloading. But in saying that, if children have access to cheap discounts which supermarkets run on beer, at times, I'm not saying illegal, but discounted, that could be just as easily a issue as, say, teenagers preloading late at night before coming into town. So I'm struggling a little bit to say on where I would sit until we see evidence of where, because the object of the Act is to reduce harm, I get that, but we also need to be making sure that we're targeting what the actual issues in our particular communities are. And I would say the RTDs are probably a bigger issue than, say, beer sales. But that's just my personal anecdotal.
And I think that's a good base of information. I accept that, and I think that's a very good level of granularity. We're going to have to drill in more effectively into this with the evidence we provide.
So if we, for example, if we said, if I could just give you an example, if we said that all off-licence sales were stopped on, say, Monday to Friday between 2:30 and 4 o'clock, which we've done occasionally in locations close to a school route. If we did that, how would the supermarkets, if they say, well, we only sell beer and we're not going to be selling beer to kids, how do you expect that to go over, again, without us having any?
Yeah, and I think that's a question we're going to have to take into the more specific conversations with the police.
I'm sure we will. Yeah. I'm sure we'll be asked to take it into consideration. All right. Okay. Thank you. Thank you, Madam Chair.
So I think here's the opportunity. So the information that you want more things on, to ask those questions here so that Greg and JP can go away and get that information. Whilst it is a workshop and we are sort of trying to just get some parameters, we're not fixed, they're not fixed, and remember we've still got a little bit more work to do around here, but we're trying to keep these workshops as transparent as possible so the public can be engaged and can follow what we're doing, and for councils to have the opportunity to ask for more information, to actually set the strategy and direction before it actually comes from the staff. So this is why we're trying to do this. And I know you're saying on the one hand you don't have enough information, but on the other hand we're trying to find out what are the things that you want to know, what are the things that you want a bit more of a steer on, what are the sort of, so that when by the time we get to a policy we've actually got the direction, the information and the things that you actually need to make a formal decision before we go out for
Just for clarification, I have no problem with what we're doing today. I just think if we're being asked to give direction, I will find that hard when, again, I can just, like, I'll come up for questions for Africa. Like, we can be here till midnight if you want. And, you know,
Please
I've
not.
got form here, so, I can do it, don't you worry. But I think if we're actually talking about trying to give direction to the staff so that they know, that might be slightly harder today. That's all the point I'm making. I think at some point we probably need a further workshop to do the actual direction side of it. But yeah, thank you.
Yep, accepted. And actually, though, I've just assumed, and a question, one of the questions you asked is one we do need to follow up on, and you talked about the different alcohol types, but there's a specific one here about the number of infringements, so sales to underage people who have been, so there's that kind of catching inappropriate sales of alcohol. So again, that's a question there that's fundamental to supermarkets and a challenge for off licences around that. And so the infringement piece there is probably quite important as well. Councillor Patterson.
Thank you, Madam Chair. Yes, just carrying on from what you've just mentioned, that would be something I would like to see. It's a lot harder for a school person to stuff a bottle of wine up their jersey than it is for someone to go in and pinch an RTD, because it's not likely that they'll be sold, knowingly sold to underages. If anything, they'd be flogged. So the supermarkets, from especially my local, they're pretty sharp. I've seen them catching people with all sorts of stuff, but it's the small stuff. And beer, you didn't need 3 or 4 of those to make any difference to your equilibrium, but a bottle of wine up your shirt is highly unlikely. So I'd really like to see the alcohol types that are being consumed and being found and causing harm by our tamariki, our rangatahi, before I make a final call on that. Thank you.
Okay, so if I take that, it's alcohol types and infringements to underage people, and then coming out of that, if there is some evidence that there are different types of alcohol being sold, then that will drive a differentiation in a potential policy between supermarkets and off licences, given that supermarkets don't sell. If there is that what we're seeking here? If I could. Okay.
I would just make the point, Madam Chair, if I could, that supermarkets do sell ciders, I think, and sort of those, sorry, what are they called, scrumpies, or I think some form of those. So I would just remind that there are options for young people at supermarkets too. Not RTDs, but there are, shall we say, not that I've ever partaked, but I've heard about it from others. So
perhaps if we draw that differentiation then, but and if I, not really being a cider drinker, but if we call the cider wines and beers as against the what I'll call the hard alcohol, the spirits, if that's the right terminology.
Yeah, we'll have to see what kind of breakdown they can provide.
Okay. Any other questions on this one then, around, for example, the school routes or maps or anything else? Councillor Waru?
Sorry, it might be a bit out of the nowheres, but you've got the LEPs for all those different areas up there. Is there any information around the sort of the impacts of the times and changing and or positive or negative, whatever they might be?
It's a really good question, thank you. I think the Auckland LAP was quite a landmark case, and that's quite recently gone through. In speaking to a number of people, and including Dr. Hewison, who's been involved in that process and very involved in a lot of alcohol policies across the country, the off-licence hours change in the evening specifically could have a significant impact to harm across the community, and almost this is the area that could make the biggest difference.
Hence my question.
That is anecdotal, and obviously we would need to gather some evidence as to what's happening from 10 p.m. onwards and understand that. But from discussions with him and with some other councils, this is really the area where you could get significant change.
So my understanding, there's some national evidence or information that's in place. The question is, what does that mean for us? And I think that's the piece where we have to match this.
How does it apply to the
sort of the national study implications question to the what does our hospital and what do our police see locally, and is there any more direct correlations between another particular location, and again this is what Dr. Hewison can potentially do, where we may be demographically or geographically similar, that provides a little bit of extra clarity, but really it's this, often there's the national studies versus what's,
and then there's the Rotorua studies.
Yeah.
Cool. And I do really mean that in the true sense of the word, the negative and the positive impacts. There might be some, might be business, running in certain times, might like that kind of later time to be able to restack or restock, and things like that. So it'd be good to know. That's a good directive.
But I think the critical piece here, and it's probably why it was first on our list, and it's got a couple of other nuances to it around further off licences. This is the area of that's been identified that has the potential greatest impact on harm, because there's a heck of a lot of controls for someone on a non-licence and a lot of implications for someone with a non-licence versus an off-licence situation. So this is the area of potentially the biggest impact if you choose to go down that route, and again it's part of that evidential base for your decision making, which probably gives us a chance then to talk about on licences.
Before you go there, JP.
Great segue.
Just back on that off-licence one, just a question of, I suppose, fairness and equity. So with those other regions, do they differentiate between supermarkets and off-licences? Or are they all...
Some do, some don't. So it really is dependent on the areas and what evidential base they build. Some of these local alcohol policies are up for renewal in the next sort of 12 to 24 months. So some of them are a little older as well. Tauranga is quite a recently adopted one, and Auckland obviously recently adopted. With I think some of the others are coming up for adoption, in the next year or two. So they probably will be targeting some different change in theirs as well.
And within there, are there any best practice examples of where you talked about school routes? So then, if you happen to be a off-licence which is not anywhere near a school, you can stay open. But if you happen to be on a school route, so that's that question of equity and fairness. So, are there examples where we can show that's been applied in other policies which will have the...
Look, I think that goes back to the nuances that we'll come back from with, again, Dr. Hewison will be watching this and picking up on some of these things for us, and again we'll be inquiring into the evidence base of whether there's actually any changes here. It might also be a case of, is there a chance to triangulate some of the information about, so what does that do about infringements of underage sales to minors within a particular area? Is there any other locational issue that comes through into some of those? So again, that's part of the information I think it's really important we put in front of you.
Okay, thank you. Are there any... Oh, sorry, Councillor Kiriopa.
Thank you. I have 3 questions, please, through the Chair. The first is, I note in the last couple of years, Third Place Cafe on Lake Road have applied to extend their alcohol licence, their hours of trading, and there's been feedback from the Ohanamatu community that there's already another bar in very close proximity to the village, has come through really strongly in that they haven't succeeded. As part of this process, has it been considered to look at across Rotorua any of our communities who have raised issues around the number of places selling alcohols alcohol within suburbs. Is part of the process going to be collating that so that you can identify as a council where there might be issues with too many places impacting on communities?
Councillor Kiriopo, just first off, just a caution, we can't talk about specific sites here, so we can't talk about specific licences that are currently in place. We are going to come to the question of proliferation, which I think is where your question's coming to, so I don't know, JP, do you want to wait till we get to that part if you're okay with that, and then they can talk to the density and proliferation, and then I think that goes to your question, Councillor Kiriopo.
So I've just got one more question then in relation to the Auckland case went to court. If we were to do the same thing here, how likely is it that we would go to court?
That is why we are building such a strong evidential case. Yes, there's every chance that we will be challenged on this. We've obviously got case law to support this and the way that Auckland did it and won that case. We have been and will continue to research that Auckland case and make sure that whatever evidential base we do build is supported by our local data, and so that we find ourselves in a strong position there.
I think it's one of those challenges that what's so good about Auckland is it was an extreme focus, and why it took so long and why it did end up with the legal challenges it did. It's become a very sound test bed because it has been through that process. So that's why when Dr. Hewison presented, it's given us a very clear view about what's required evidentially to be successful and what's not, and also just going through that process information.
I think Your Worship's got a question.
Thank you, Madam Chair. Through you, it just goes back a slide where it talks about alcohol advertising at street front level. So mainly just in regards to the off licences, when we talk about community safety, I know we also have, CPTED, crime prevention by environmental design, and then regarding sensitive sites such as schools. Yeah. Is that how much detail can we go into within our local alcohol policy to prevent that? Because I know certainly in some sites there is a large proliferation. There's a massive flag on main highways that say alcohol here, and the advertising is all the pretty pink stuff that just promotes certainly underage and perhaps unsafe drinking. So I'm just wondering how detailed can we go with that? I think largely we've got it right already, but things like that could actually, a change in that could actually have a better impact on what we're trying to do. And I am aware, I think places like Queenstown are very strict on their displays of signage. So as a tourism destination, it looks a lot better as well. Yeah.
Thanks, Your Worship. Yes, so we will be getting to discretionary conditions shortly, but Tauranga and Gore that I've picked out as the two areas that have got significant discretionary conditions within their LAPs, and they go into quite a lot of detail, and we can run through that if that's okay with you when we get to the discretionary conditions. But they really do have quite a long list of what is required in certain circumstances, or what could be required in certain circumstances.
Okay, Councillor O'Brien. Oh, okay, all right. So we'll move on now to on licences.
Just picking up on this space. Again, one of the key pieces here is, and it was raised previously, is you have to provide the opportunities for people to find somewhere appropriate to have a late night drink. And so again, we had a blanket 3 a.m. across the city, so we're just trying to pick up on some variations here. So some of the information that we got back was just about managing that critical time, usually after 2 a.m. And so really this question's around one-way doors and conditions that need to potentially be imposed on premises for their late operations. So we weren't proposing at this stage, from the information that we've received, to make much of a significant change to the CBD, and I've got each street separately. But again, you can see there's some nuances being picked up in other policies here too. So for us, it's a case of understanding the unique circumstances of any premise and providing the DLC with the opportunity to assess whether any particular conditions are relevant. Now, if we're effective in this space, there might be a fantastic premise down an alley. Well, that would be a really important one to make sure a lighting consideration was put in place around as a condition, or surveillance cameras or something like that. So again, you come back to the unique circumstances of the premise, particularly operating late or early into the morning. So it's a really important part of that assessment of the individual premise and giving that latitude to the District Licensing Committee.
Okay, so councillors on that slide then, any information you want or questions? Councillor Patterson?
Thank you, Madam Chair. Just would have to be very specific about the CBD. What does that actually mean and where their boundaries extend to when we make that change? And also, I'll save my other questions for later. Thank you.
Okay, Councillor, Your Worship.
This might be a bit of a detailed question, but I'm just wondering if we were to explore earlier closures. I mean, there's only so much we can control. At the end of the day, some people choose to drink well into the morning, and I would just be concerned if we were to prevent, I don't have a particular view, but is there any evidence that if the closure time is earlier, people just go back to the neighbourhoods, continue drinking, and we see greater disorder? I just want to make sure that we would fully understand any consequences if we were to make any changes of, are we ensuring people are drinking in a place that should be safe for all intents and purposes, or would we be pushing that issue back out into the neighbourhoods and receive, like, as an example, council looks after noise control. Have we seen in the past when it closes earlier, we've had more noise control complaints in the neighbourhoods? I would just be I'm not sure if you can answer that now, but I'll be quite interested to make sure that we fully understand implications if there were any changes.
Thank you, Your Worship, and that's a really, really good point, and we'll take that away and we'd have to add that into our research base and make sure we don't have any unintended consequences for potential proposals that are brought forward.
And I think the evidence from other locations has been sort of that staggered nature. The last thing you want to do is tip everyone out at the same time and at the witching hour, because that creates an additional problem or burden often on the streets as well. So yeah, we'll get some information on that.
Okay, Councillor Patterson.
Thank you for your indulgence, Madam Chair. It goes, I've been thinking about this, that what do we want to be? As Rotorua want to be known for nightlife. I think someone called it a nighttime economy, because we don't really have that at the moment. We're kind of tinkering with it. We used to be there many years ago when there were places that you could go until 3 o'clock in the morning, and there was very little trouble afterwards because people went there with the right attitude. Different story now, different times, I get that. But what do we want to be? Do we want to be known for having a vibrant nightlife? And if so, then this decision could impact the future of that, going hand in hand with our future development strategy, all of these things. This is a very important, this particular one, especially for the CBD, could shape where our city goes for the next 10 years, if not more. So it's important that we factor in what do we want our city to look like.
I think, Councillor, you've actually touched on something quite important too, because it also goes to that picture of the CBD effectively. We are increasingly seeing and trying to encourage, if not living in the CBD, accommodation in the CBD, or at least facing our lakefront, which is really valuable and really important. There's a double-edged sword there of great nightlife, no sleep in your motel afterwards. So I think we've just got to, I think that goes fundamentally to your question then about how we create a good, vibrant, positive city with a whole bunch of objectives being achieved without eroding some of our other baselines we're trying to do, which is a well-used, well-livable city and a safe city. So I think you're absolutely right in asking that question.
Thank you, because what I'm trying to get at with the FDS is maybe we have to look at a zone in the city and say that's the only place that we can really safely have a late entertainment area, because there's no motels, there's no anything around it that's likely to be affected, and just encourage development there. I mean, the market is doing it itself at the moment. It has led us to where we currently the situation is. But if we want to prevent hassles between neighbours with noise complaints, that would be smart to do some serious thinking about where these places should be.
Thank you, Councillor Patterson. And actually, I think you've hit the nail on the head, as JP had said. The team are actually working with JP's team and Damon in ensuring that there's that link between the FDS and what this looks like going forward. So, yeah, we definitely, that is on our radar.
I think it does, with the right tools too, it actually helps encourage the right outcomes, and some of those discretionary conditions keep making it more viable to have things in the right places.
Thank you.
Councillor Wari.
Kia ora te siamana. Just in terms of this, I'd say what you're proposing is actually probably what's already practiced. You know, there's the practice, and then there's this. Most people, you know, I'm not saying I know all the clubs or anything like that, but as a musician as well, and not that long ago, this is sort of what was practiced anyway. Because otherwise it would just get too much of a hassle. By the time we got to closing time, they had to all be, you know, trucked out. But I just think, just a word of caution, you know, sometimes and I hark back to when we talked about, when we discussed the dog legislation for here. I just want to make sure that we're not penalising those who are running well and doing good, and the other part of the policy can be to empower those that might need a bit of bit of support to raise the level. So that's all I'll say for now for this part. But you know, there's practice and then there's policy, and you know, I think most people in this industry have good common sense. Kia ora.
Okay, Councillor O'Brien.
Thank you, Madam Chair, for you. I'm quite happy with what's been proposed here, but basically the status quo. 3 a.m. closing. Now, of course, I'm home by about 9, so I can't relate to this, but I am told by those who stay out late, Rawiri, that 3 a.m. closing, how often in this town would a bar be open till 3 a.m? And that's including summertime. One, they can't afford the wages. Two, the simple sales just aren't there to justify it. So 3 a.m. is not mandatory. They don't have to stay open. It's there if they need it. But I would say that in Rotorua, particularly in the current economic climate, the amount of locations actually open till that time, frequently, you know, again, don't know myself, but I'm sure, you know, I'm sure we can gain evidence on that factor down the track. But so I'm quite happy with what's proposed here at the moment. Thank you.
Okay, so I think so what we've got here, so this is just talking about the on-licensed hours in the CBD, and then we're going to talk about a carve-out for each street to get that combination of living as well as the nightlife and the restaurant. So unless there are any other questions, I think JP and Greg, you've got enough direction around this slide. Unless there are any other questions, councillors, I'll move on to the each street one.
So, councillors, this is where we did have a different view of the footprint, and really the piece here we've got is the information that we've received from our own regulatory department. So we have a significant volume of noise complaints that operate out of as a consequence of Eat Street, and we've enabled that. So again, it was council's development there. So the number of premises in one location, so that's a significant challenge in itself. It actually becomes a bit of a regulatory issue for us too, because who's actually the source of the problem is another challenge when you've got 10 plus premises in close proximity. The significant number of noise and nuisance complaints that we receive in this area, consequentially, it's significantly higher than anywhere else across the CBD, and there is a number of residential properties and accommodation offerings within close proximity of Eat Street. We also enable half to 2/3 of a premises capacity out on the street, in effect, under the roof we've created, and the roof structure itself, whilst it's absolutely amazing and it gives us Eat Street, also means it's amplifier street. So the sound goes off in different directions as a consequence. So difficult to isolate problems and that close proximity of residential and accommodation. So from our information, we have a very clear issue around noise complaints and nuisance. Obviously, we've also got then the police discussion and to fold into that from the evidential base. So probably one of the questions we have, and probably one of the directions of travel we're taking, and I'm sure it's going to be the issue du jour of this process, is this discussion, both from those four and against what's being proposed. So we're suggesting within Eat Street there needs to be some consideration of an earlier closing. Now, and potentially that creates an earlier one-way traffic, and again, the potential there of those discretionary conditions we've talked about previously being available to the District Licensing Committee, but equally we also have our own footpath trading policy and our own agreements with operators, which is separate. So we do have another mechanism to have a conversation with operators, but this is one of our challenges, and we named this Eat Street and we talked with the operators at that time, so it's been operating for a number of years now, obviously, about the focus on it being Eat Street. So that's one of our challenging areas, and as I say, the problems with the facilities in that space is the dining outside, and also the inability to separate the causality of some of those concerns to neighbouring areas. So hence a different carve out of Eat Street being discussed, and again it's important for us to make sure we've got that evidence base for you to consider.
Okay, Councillor Wadu.
Kia ora, me te tiamana. I'm not sure I'm totally on board with this one in particular. I mean, it's like when you decide to take up residence next to a main highway, you know you're going to get some noise. Maybe it's a better, it's looking more at it by 1 a.m. Perhaps the noise levels are, well, can be reduced then, so everyone has to comply with that, but I don't know about closing full stop at 1 o'clock, because there's some pretty pumping places down there when they get going. Kia ora.
Thank you, Councillor Wadu. I think there's an opportunity through the footpath trading policy as well, and through the LAP, to have a look at does trading move from outside to inside at a certain time, and then that is the noise control aspect potentially working in that space. We need to do a little bit more research on that to understand whether that's going to have the impact or desired impact that we want to have in that space.
Thank you. Kia ora. Also, it's not so much a question, maybe a suggestion.
It's a question. Okay, all right. So, Councillor O'Brien.
Thank you, Madam Chair. Gentlemen, can I ask, sorry, just reading what's in front of me here, do you plan to, or do you differentiate between, say, a bar or restaurant with a non-licence as opposed to a nightclub, and that is specifically there to be a nightclub, and with the sort of noise and obviously bands, etc.?
It's a bit like a definition of a pig dog. There is no definition of a pig dog or a hunting dog. There's a dog, and it might be a menacing dog. So a nightclub is not necessarily a granular definition. If you put on a live band, do you become a nightclub? Or so we actually have a licensed premise discussion. So I think the issue we've got there is how you try and behave with a premise, and unless maybe it's a dance floor, but maybe that's the issue about the outside inside, because that's been some of the challenges we've had, is that late. But equally, it can also apply to noise complaints of the outside band in that open areas being amplified by a roof or directed by the roof in a certain direction again. So I think this is where we often have a differentiation between a normal premise that might have all of its activity inside versus, in our situation, half to 2/3 almost being outside, and so almost being that the focus. So again, it's hard to find a definition of what's a nightclub versus it's a licensing question, not a use. So
But forgive me, Dave, most of the locations currently in each street would be a restaurant, would they not? The vast majority would be a restaurant with a liquor licence.
Yeah.
So I don't really see how we could say they're nightclubs. The remaining issues would be identifying those that perhaps closed at 1, as opposed those that wanted to, as I say, attract that clientele, probably younger one, between, after midnight. So I don't think it's quite as hard as we're
but I think that becomes the discretionary conditions question after, and I think that becomes outside, inside discretionary conditions, and also that sound mitigation question. But
also, sorry, if I said I wanted to open a nightclub in each street, location X, my expectation would be that your planners would sit down with me and say insulation would be something, blah blah blah, noise after a certain time, levels, etc., like that. Again, I think that there's work there that you can do to identify, as I say, just to differentiate the types of.
I think at that point we're starting into discretionary conditions. At the moment we don't have a long list of discretionary conditions, and I think that's probably a really good one for us to unpick as part of this discussion around those discretionary conditions question.
Okay, thank you. Thank you, Madam Chair.
Your Worship, did you have a question?
Thank you. Through you, Madam Chair. Just curious about maybe further information on the residential accommodation proximity. Obviously, this is quite different compared to where other bars may be, because you have a number of hotels nearby, you have a number of apartments nearby, so I can appreciate the concern. Is the reason for suggesting a direction that closes earlier because of the amount of residential accommodation compared to others? And then I have a further question.
When we've talked to our regulatory team, the level of noise complaints are focused for the CBD predominantly on Eat Street, and the mix of complainants are a mix of commercial accommodation as well as residential. So there's off the top of my head, I think it's about a 50-50 split between residential impact and complaints that are emanating via the accommodation providers. So obviously in that area, you start drawing a circle around that, and you've got the Regent, you've got Novotel, you've got down towards the Pullman. There's a number of commercial accommodations within that circle, and that's been part of our challenges, certainly from the regulatory team, about how sound comes out of Eat Street as well. So again, you can see Novotel is significantly further away than, say, the Regent or even the Pullman, but there's a range of sort of acoustic problems that are emanating from that and creating complaints. So it's a mix of both residential and commercial accommodation.
Thank you, because I appreciate that could have, bad reviews have significant impacts on whether they're accommodation or from Eat Street as well. And then just the final question, regarding an earlier closing time, do we know, or are you able to share what time those noise complaints come in? Are they between the 1 a.m. to 3 a.m. or is it just, so, if it's 8 p.m, then that may be seen as reasonable. If it's 2 a.m, then not so reasonable.
Your Worship, that's a good question. My recollection is generally people who are staying in a city expect a level of noise to a reasonable level. So my understanding is most of the complaints are post-midnight.
Okay, any other? Councillor Patterson?
Thank you, Madam Chair. Kind of echoing Councillor Waru's comments, again, my experience of being in Rome in the Jewish Quarter, which is a very historic area with lots of residents living there all the time. It's noisy as hell till about midnight, and then it just goes absolutely quiet. And then by 8 a.m, they're up starting the restaurants again. But they're really respectful. They clean the place you never know that they're even there. Then all the tables come back outside. Now, Eat Street is a permanently built facility that we as a city all jumped up and down and said, wonderful. And I'd have to agree with Councillor Waru that if you go and stay in that area, you know that Eat Street is there. It's in all of our marketing. It's trumpeted as one of the draw cards for coming to Rotorua because it's quite a unique experience. I imagine that the thump, thump, thump of heavy bass might get up people's nose, so that could potentially be limited. But the noise of people having fun and enjoying each other's company, I think that needs to be given a bit of leeway. Thank you.
Okay, so we'll move on now to the proliferation, and you want to talk to this, and then you can take Councillor Kiriopa's question.
So proliferation, the number of new off-licence premises, currently in our LAP we have no restrictions on this. And just having a look at a proposed direction, we've got a couple of LAPs across the country that actually impose consultation with sensitive sites prior to application of a new site, as well as community impact statements to accompany the application, and I think that might lean in towards Councillor Kiriopa's question earlier. So the question really is no new sites versus saturation versus deprivation areas, and so it's having a look at where the harm is happening, how many or how much access do people have to those facilities or those off license facilities. Tauranga have a no new bottle stores within suburbs of a deprivation 9 and 10. Gore has a requirement for a social impact assessment to happen, and that comes forward with its application to the DLC. The Western Bay of Plenty has no new licences for bottle stores, should be issues for premises in the Te Puke, Maketu ward areas. So really can go either way. You could actually identify areas where you believe that shouldn't happen. We're currently working with our GIS team and overlay the areas of deprivation versus the sites in specific areas across the community. So you would have a very clear picture of what are the high areas of deprivation, how many bottle stores might be in that area, or off licenses.
And probably the other piece too is, and correct me if I'm wrong on the distance, there was kind of a view that, that there's a standard operating of a useful community bottle store or off licence or supermarket had about a 2 kilometre circumference. Yeah, and so that would be one of the things we just plot to give you a feel for the coverage of bottle stores. We all know where our locals are if we need to pick up a bottle of wine or anything like that. So it's just really easy just to have an idea of where you might have to go for across this town. Now, for that, it gives us a chance then to say, have we reached a level where we've actually got extremely good coverage or not? And again, it's one of these questions for us about talking about, is this an option of considering non-proliferation or at least a period of stopping it with review?
Councillor Kiriopa, did that answer your question, or did you want to put your question?
Sure, I just wondered if, as part of the process, Council could go through and see what community feedback has been on bottle stores in their communities to have a good understanding of where there might be issues. And my second question is, are there any local organisations that might be able to give insight into that sort of thing too?
Sorry, the short answer is yes. I don't have the list in front of me at the moment, but there's a number of well-being organisations and trusts that we have already engaged with and will continue to engage with through the October-November period. and they have already inputted some valuable information into what they believe they would like to see changes in that space. We're not finished with that process yet. We obviously need to consult on both sides of that equation, so or engage on both sides of that equation. So we're still busy with that. Sorry, just coming back to your previous question. So yes, we can drill into as much detail as we can find on previous complaints around specific areas. But by proposing a community impact statement or assessment every time a new license needs to be renewed, or a license needs to be renewed, or a new area comes forward, there's an opportunity for that analysis to take place at that stage again for the DLC to consider as well.
Will those organisations that you're talking to include community associations like the Macquarie Association, for example?
Could do. I've just got a list in front of me that the team are sending me as we're talking. So we've got the Māori Health Support Services, Rotorua Youth Centre, Māori Men's Health Organisation, Addiction Services. So those are the groups that we've spoken to or are speaking to currently, and we can broaden that to other community groups as well.
I think we have to strike the balance too, though. My caveat would be on how much we do up front and how much we try to encourage the submission process to actually elicit this thing. And I think this is that awareness and why it's so important. We've proposed an extended submission period so we can get information out there to the community and make sure that if anyone has some comments they'd like to make, because this is a really important policy for the community, that there is plenty of time for them to shape their views and put them in.
Okay, we've got one more slide, I think, around discretionary conditions, and I realise we're over time, so we'll just quickly take this
a quick question,
last
please,
slide.
Madam Chair?
Sorry, what was it?
I just wanted to ask just a quick question about that
Sure.
last slide. Thank you. With regards to this, and you were talking about renewals, say we come up with a new policy or a new sort of direction, would it then apply so when it's time for renewal, if they are not in line with the one that we might sign off moving forward, would that then be, that's it for that place, i.e., and we all know this, there's way more stores in particular areas than there are in others. So we are saying, okay, no, we're going to limit it to a particular number in a particular distance, or even just taking into consideration the social impacts, like you already talked about. If we make those calls now and in the future when it's time for renewal, what would be the impact on them?
So hopefully I can answer your question, Councillor.
Sorry, I know you're not a crystal ball or anything. But
no, so with regards to new hours, and if we go back to the off licenses, changing of hours and on licenses, those will come into effect within 3 months of the adoption of the policy for all licenses. They will have to comply within 3 months of the changing of hours of operation. With regards to any other policies, such as discretionary conditions, some of these that we might add in, they will need to be implemented by the DLC license by license as they come up for renewal. As they come up for renewal. So that will be a slower process as they come up for renewal. We won't be going in and all of a sudden having to change every license. But the hours of operation have a 3-month window, and within that you need to be changing your hours of operation. Okay, thank you. Thank you very much.
I think the intention, though, and so we'll just have to make sure we're really clear about this, the non-proliferation wasn't a sinking lid. I think it's the kind of the question you're asking. So the non-proliferation was to new into particular areas as opposed to existing premises. That still might have to do their new licence anyway. So, but it's the further additions or further proliferations as opposed to a sinking lid approach.
And sorry, just one more thing, sorry, on that. With reference to the Auckland LAP, I think they've got a no new sites for 2 years, so they've actually put a time period on that. And the research that we're going to do and evidence that we're going to build will hopefully substantiate which area you want to be focusing on. Thank you.
Councillor Kirapa.
If enough information came in that there was an issue with too many, could that change to a sinking lid policy?
Can I get back to you on that one? Thank you.
Okay, so that's something we can just take into account. Probably don't need to give a definitive answer here, but I think we've already covered that across density sites, sensitive areas, proliferation. So take that as an action point for Greg to come back on.
Can we also ask what's too many though? How do I identify too many? Well, is this going to be informed community feedback or people just saying, I don't want a off licence in my area? Again, what's too many though?
Yeah,
I think
is too many?
yeah. Remember, we're going to plot this on all the maps with the catchments and availability. So again, I think that's the evidential basis of saying, well, what's the geographical spatial representation? Now that leads to another conversation.
Chair, could I just ask, sorry, on where it says consultation with sensitive sites prior to application, could I ask what you mean by that? Because sensitive sites being, educational or schools, churches or marae, you can't have a liquor licence within, is it 500 metres? Sorry, I forget what the... So why would I be consulting with someone when I can't actually have a liquor licence?
Sorry, JP and I are just having a quick chat if it's 500 metres or 200 metres, but I think, yeah, it could be. From my understanding, that isn't consultation, sorry, just on that one. I think it's the licenses that so for example, there's an already established licence and a sensitive site moves into that space. That's very different to if you bringing in a licence for or close to a sensitive site that's already established. And I know we are seeing some of that in the inner city where there may be, churches, schools and such moving into where there's already established, liquor off licenses. So I think it's 200 metres though.
Oh, sure, I'm happy to take that. I'm still not sure why I'd consult if I can't have a liquor licence close by. But if you're saying it's already existing and then a church moves in, wouldn't they have the opportunity to oppose when I renew?
Yes. Yes, I think you would.
And I think this goes back to the other question too, which is a renewal was treated as a new licence and that was the kind of information you got from the district licensing former chair. Those changes mean it's a public process in its entirety for even renewals or are treated as new licences.
And sorry, your second one, the community impact statement, who would do that? Would that be something we would charge for, an independent person? Because if I'm going to be paying $1,000 to someone, I'm probably going to make sure it's sort of, shall we say, friendly towards my application. So who vets if it's what the requirements will be, what it's marked against in terms of what you consider community impact? How will you flesh that out?
Councillor O'Brien, I'm not sure if it's kind of an operational thing, probably more for the district licensing committee at this point. So if we just take some notes.
It says that it's to
sorry, I can answer that one quickly. Sorry, that's a really quick one. That's up to the premises or the licensed premises part of the application to do. So they will have to do that the community impact assessment. So it's not a council. It would be the licensed premises.
Agreed. So again, I raised my first point that if I'm going to be hiring someone with my own money, you're going to put this in front of the DLC with what research? Will you make funds available for them to research the assessment? Who's going to... Okay, thank you. That's good. Thank you.
Okay, can we just quickly do this last slide because I'm just conscious of time. So we've got one last slide around discretionary conditions.
Right, so the current LAP has 4 discretionary conditions that sit within it. The implementation of SubTED principles, which I think, Your Worship, you mentioned, the alcohol product advertising as well, host responsibilities and food requirements for special licenses. This is something that Karen Hunt did touch on when she was talking through her presentation. Really, there's quite a bit of work for us to do with the DLC and the outgoing chair to understand what is coming forward to the DLC on a continuous basis. Tauranga have quite an extensive list of what their discretionary conditions are. I've got them all up there, but some interesting ones would be patron to security ratio, patron to bar manager ratio after certain hours, additional security after 1 a.m., transport provisions. So there's quite a quite a lot that you could add into that. Gore also have some sort of management incident reporting that they have to do, utilising subsidiary principles and premise layout and design. So really can go quite broad on the discretionary conditions, noting that there would be no point in us putting discretionary conditions in that the DLC would never likely use. So there would have to be some pretty clear guidelines from them as to what is really an area of issue for them.
And again, that's the exhaustive list again, and I think taking the councillor's point, there's a cost imposition on licensees who have to make these applications and prepare to address some of these. Even listening to your conversation about Eat Street, maybe one of the discretions there, and again, something we'll just have to explore, is the sound mitigation. So if you're starting to talk about the harm or the nuisance creation issue that you're trying to address, maybe we have a unique one, which is the sound mitigation requirements for particular locations if the licenses go beyond a certain time. So again, this is that kind of stuff that, having listened to your discussion today, I know it's not an exhaustive or finalised conversation, but it actually helps us in saying, hey, there is other options for us to consider, and potentially there's another way of sort of resolving or addressing some of the challenges to get the outcomes you may see as being necessary. But that's certainly that's the exhaustive lists, and again, it gives us the chance to say these are not all imposed. Remember, this would be the District Licensing Committee looking at the unique circumstances and location of a premise or the hours of operation being sought, and starting to say, hey, for the management of harm or in response to a community submission, what are the issues we need to address in a particular location? So it's not a everything list.
Okay, councillors, so final points, and then I'm going to wrap this up. Councillor Patterson?
Two final questions, if I may, Madam Chair. Just those examples you've given from Tauranga and Gore, are they set by the District Licensing Committee, not the council?
So those are included in the local alcohol policy,
Yep.
And then the DLC will implement those on a license by license basis.
Okay, so those, just to be clear, those are just examples. You're not suggesting that this is the path we follow?
No,
Okay.
those are examples that are currently in the Tauranga and Gore local alcohol
Right,
policy.
thank you. And my second question relates to one of those earlier slides. You showed the timeline, and you said that this month, I think it was October, was going to be consulting with key stakeholders. Can you clarify who they are, please?
Sorry, I mentioned a few of them earlier, but at the same time, we're consulting with the police, consulting with Health or Ministry of Health. We're also going to be working with some representatives from the other side of the coin, so the alcohol related or licensed representatives.
So the hospitality
so that
industry.
we can try and get a comprehensive view from both sides.
Thank you.
Okay, thank you. Did you have a question, Councillor Waru?
Yes, thank you. First question, what does no single sales of shots or pre-mixed shots mean?
Sorry, I'd have to go into my into the policy itself, but from my understanding, I think that's for off-licensed premises.
So I have to buy a bulk.
Yeah, actually, I thought that was to do with off licenses. Again, I thought it was touched on by the presentation that the DLC former chair made, which was when off licenses particularly break up a six-pack and sell things individually. Okay. So it's the ability to get an RDT singularly or a single shot. That was, I think, the issue of the concerns there. Well, we'll just check on that one because, again, that was just examples we've grabbed.
Thank you. Now, that makes a bit more sense. And my last question is just really around the, there's the timeline, but in this actually with the continued work to be done to include discretionary conditions frequently required by the DRC, is that all factored into the timeline? Because that seems like that can be quite an onerous task. To put that all together, unless we're going to be very good people and just keep everything nice and simple.
Yes, so that is built into the timeline. We're currently engaging with and have received some information from Karen Hunt as well, and we're working with our own teams internally to make sure we gather the right information of what's coming forward through those applications. So we do have a lot of work to do in a very short space of time. Yes, we'll acknowledge that. But we've sort of going at it pretty quickly at the moment. So
You're confident you get through it?
yes.
Yeah, and can I just add one piece? It actually tries to give the DLC some flexibility to be supportive. I know some of you read that as being unsupportive, but there's a potential here of a licence application getting a flat no, because they've only got 4 conditions on which they can apply some discretion, as opposed to, okay, there's a unique set of circumstances here, I'm authorised to use a discretionary condition to mitigate some of the problems, which may turn a flat no to a yes with some conditions. So just balance that off, and we can certainly make sure we can give you an understanding from the DLC as well, the kind of challenges that creates, because it also goes to the community feedback and the issues that are raised through those kind of processes. Is there an opportunity to make sure that the problems and the harm or the nuisance is mitigated, which takes away from a DLC just having a hard yes/no?
So I just want to add, it's not a question, it's just, this is the alcohol policy review, but I would urge you to, and you're probably already doing it, but I don't know, to look at the food policy as well, along with other things that might have, they're all connected up, like you've done out there. So you don't get one saying yes to something and the other one going no to something, that's the worst that could happen. So, kia ora.
Okay, thank you. I think councillors will call this to a close now. So there is still a lot of work to be done by Greg and his team, and timeline that we're kind of working to is the council meeting of the 27th of November, so I understand it, for sign-off of the proposed policy for consultation, and then that will allow a decent consultation period over the Christmas New Year period through till about February, when hearings would then commence. So that would be the first piece of work that councils would be required to undertake in relation to this, is to then hear the community feedback. So on that note, Councillor Waru, closing karakia, please.
Kia ora tātou. Looks like some of us councillors have to go and do some research soon on this review. Kei noi tātou. Kia tātou katoa te ata whai o tō tātou ariki e hui karaiti, me te aroha o te atua, me te whiwhinga tahitanga ki te wairua tapu ake, āmi.
Thank you, Councillor Waru, and
Thank you, Madam Chair.
Thank you, councillors. We'll declare that workshop closed.